So your attorney calls and tells you it's time for trial, and you've got to come into the office to prepare for both your direct and cross-examination. What does that mean? Welcome back to the Williams, ELLEBY HOWARD, and Easter YouTube channel. This is Marc Howard. I'm Jared Easter, and today we're going to talk to you about the difference between a cross-examination and a direct examination at trial. And I'm excited because Marc has a ton of experience on this topic, and I think me, along with you guys, are going to learn a lot about the difference between the two and maybe some trial tips, insider knowledge from somebody who's done it a whole lot more than me. So Marc, let's start with what is a direct examination?
Yeah, so the direct and cross have different purposes, and a direct examination is when it's your own witness who's on the witness stand. So if you were the plaintiff in a case, your lawyer would put you on the stand, and the point of it is to have you, the witness, tell your story. And there are certain rules that go along with that. The most important is that the lawyer cannot ask what are called leading questions of the witness. The difference between that and cross-examination is it's a witness who's hostile to you or is an opposing party, and you can ask leading questions. And I like to think of the difference is when I'm examining a witness, if it's on direct exam, it's about the witness and their story. But if it's on cross-examination, I want to be the star of the show, and I want to be the one that the jury's focusing on. So I might even have different tactics, like in direct examination, I might stand in the back of the courtroom so the jury is focused on the witness. But if I'm on cross-examination, I might be in the face of the witness so that the jury is focused on me.
And the purpose, I think, of direct examination is really to put up your case. You know, I always tell witnesses as we get ready for trial, especially my client, is this is your moment to tell the story, and it's really focused on them and making sure that, you know, the evidence gets in, because you and I as the attorneys are well aware of all the intricacies of the case and how all that goes on, but the 12 jurors that end up there know nothing. So I think it's important to, you know, kind of make sure we remember that, and we aren't telling our version of the story, but we're telling the whole version, each piece along the way, to get all the information in, as opposed to cross-examination where we want to attack or kind of take apart the story from the defense.
And that's exactly right. And one of the things as the plaintiff, we have what's called the burden of proof, which means we have to present proof to the jury of the parts of our case. Otherwise, the judge will just throw it out. And we also have to persuade the jury, of course. And so that's done through either documents or witnesses. And so an examination on direct, it's exactly what you said. You want to have the witnesses tell the story of the case and then present any documents that may support that case.
So on cross-examination, I guess, you know, the goal is for us to score points with the defense's witnesses. So what are some of the ways that you can use a cross-examination to score some points for the good guys?
Well, the most the thing that is most well known is what's called impeachment. And you know, we sometimes hear the word impeachment when you're talking about a president, but in the courtroom, impeachment means that you're attacking the credibility of a witness through their prior inconsistent statements or through documents that contradict them. And an example might be if you have a witness who has said either in public or in a deposition that the light was red, and then in court they say it was green, you can take their deposition and point out to them that they said one thing at one time and another thing at another time. What's really important about that is you got to commit them to their false statement before you then go in for impeachment. And so that's one of the best ways. The other sometimes is to just ask questions which are bad for them no matter how they answer it. So you might ask a question that if they say yes, it's bad for them, but if they also say no, it's bad for them. So there's no way out.
Is there any time where you might be able to utilize the defendant's statements or something the defendant said in our case to help prove or help win the case for us?
Yes. So one of the things is if you need something that a defendant in a case has said, there's a rule, at least in Georgia, I don't know how it is in every state, but in Georgia you can call the defendant in the plaintiff's case. And it's an interesting rule, and a lot of it is up to the judge on how it's handled, but typically what would happen is I, as the plaintiff's lawyer, would say, I call defendant Mr. Smith for purposes of cross-examination in the plaintiff's case. And if that happens, the defendant has to get up on the stand in our case, and I can start asking leading questions. I can cross-examine the witness. I can get them to agree that certain documents are accurate and authentic. And unless the judge allows otherwise, the defense lawyer cannot ask any questions in the plaintiff's case. They have to wait until it's their turn. So it can be a very effective tool if you need the defendant to be your witness, because you can still cross-examine them.
And it's probably worth pointing out too that in the plaintiff's case, unless we call the defendant, there's a chance that the defendant never has to take the stand. The defense can decide, they're kind of the keeper of their case. So if they choose not to call the defendant, then the jury never hears anything from them. We never get a chance to question them. So sometimes it's a strategic decision to figure out, maybe you need it to prove something, or maybe you just think, you get the feeling that defense isn't going to call their client as a witness, in which case it's better off for us to call him and cross him as opposed to just letting those points go away.
Totally agree. If I need the defendant to prove my case, I'm not going to wait till the defense lawyer calls them, because they may be smart enough not to. So I'll call them in our case.
Yeah, if it's bad enough, you want to keep them off the stand and as far away from the courtroom as you can get them sometimes.
Yeah, exactly. Exactly.
The joys of being a defense lawyer. So how does this work, for someone who's never been there before, as far as the order goes? I know in law school when I learned this, it's kind of an interesting, because it can go on back and forth. So tell us a little bit about when does cross happen? When does direct happen? How does that order work? And what happens if there's, say, a crazy case where there's multiple defendants involved? How does that all line up?
Yeah, so again, I'm going to talk about Georgia. There are different rules in different states. There are different rules in federal courts as well. But in Georgia, what would happen is the party calling the witness would call them for direct, and they would ask non-leading questions. And the party then goes through that direct examination. Afterwards, every defendant in the case has an opportunity to cross-examine the witness. And if there are multiple defendants in a case, it could be that they do what's called friendly cross, where they're technically cross-examining a witness, but they're doing it in a way that helps the other parties. And so they may coordinate that ahead of time. Then after cross is done, in Georgia, you can do what's called a redirect, which is limited in scope to what was covered in cross-examination. And then in some circumstances, there can be a recross to cover what was done in redirect. But typically by that point, the judge will have had enough and say, okay, we're done with questions.
All right, and one final point as we start to wrap things up here. We've talked back and forth about leading questions, non-leading questions. This could be some advice for some lawyers out there as well that I've encountered, but give us an example of leading versus non-leading, just to clear it up for everybody.
Sure, and this actually, we didn't cover this, but I always find it's much harder to do a direct examination than a cross-examination, because the cross-examination, I kind of know the answer before I ask the question. But on direct, what you would do is a non-leading question is to ask someone something like, Mr. Witness, do you know about this situation? Answer, yes. Can you please tell us about it? And then you sit back and let the witness tell the story. And sometimes if your witness is not prepared or is nervous on the stand, they may have trouble getting that out. Some judges will let you ask a few leading questions to kind of help them out, but it's much more difficult if your witness is, scared, nervous, isn't prepared. On cross, a good example would be, isn't it true that? And then you just say the fact. And sometimes it doesn't matter what the witness says, yes or no, because the jury has heard what you've said. So I like cross-examinations to be about what I'm saying rather than what the witness is saying.
Yeah, I always think of a lot of the non-leading questions as being who, what, when, where's, very open-ended. And you're right, there's nothing worse than when your client forgets the one detail you need and you can't help coach them along to get there. But it's always an adventure.
Yep, and that's, as lawyers, it's important for us to make sure our witnesses are prepared. But once they're on the stand, you can't really interfere too much with what they're saying, or the judge will get mad at you.
All right, well, is there anything else you think we should cover?
No, I think we've about done it.
Well, if you enjoyed the video, give us a like and a subscribe, and we'll be back next week. Hopefully Joel and Chase will be back with some more riveting videos for the YouTube fans. Thanks.
As personal injury lawyers, we love what we do, and we're happy to share the experience that we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when they're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.